There is a real risk to our civil liberties if we normalize the use of the Charter's notwithstanding clause. Simply, it allows politicians to pass a law that infringes charter rights unreasonably, and courts are completely neutered from striking the law down. Take Quebec's Bill 21, the central focus of litigation now before our Supreme Court. That law banned public sector workers from wearing religious symbols, so Muslim women who wear the hijab can now no longer find public employment as teachers, doctors, judges, you name it, completely unacceptable. It was passed in the name of secularism, but in effect it is an extreme infringement of religious freedom. State secularism, properly understood, protects both freedom of and freedom from religion. It means neutrality, not Bill 21-style suppression. Now, our individual rights are not unlimited at the expense of the collective good. Of course not. And Section 1 of the Charter provides for reasonable limits on rights in pursuit of those important public goods. Two guardrails operate here. First, there has to be a pressing and substantial policy objective, and two, the rights limitation has to be reasonable. The notwithstanding clause is an extraordinary provision precisely because it allows politicians to infringe a right even where a court finds that infringement to be unreasonable. Why does the Charter's notwithstanding clause exist? You might wonder why in the world anyone would think it's a good idea. And the federal fathers of the Charter, they didn't. Pierre Trudeau envisioned courts having the final say on Charter interpretation just as they do with the division of powers. Western premiers, they disagreed. Judges are fallible, they said. Of course they are. And these provincial leaders argued for the supremacy of elected parliaments over appointed judges. The notwithstanding clause was really in the end a compromise to reach a consensus. As Alberta Premier and the clause's architect Peter Lougheed put it, Mr. Trudeau got his charter, and the Western premiers got both the Alberta amending formula and a notwithstanding clause. Thoughtful academics have since called it a very Canadian solution, striking a balance between the British parliamentary tradition and the strong judicial review of the U.S., but it was also to be a solution saved for extraordinary situations. Those around the table when it was adopted have called it a last resort, to be used in exceptional situations and after careful consideration. Contrary to that original intent, the notwithstanding clause has been invoked by provincial governments more in the last 10 years than in the first 35 years of our Charter's history. The feds have never used it, thankfully, and most recently, provincial governments across the country. Let's run down the list. The Alberta government invoked it 4 times, once to preemptively prevent judges from striking down a law that violated the collective bargaining rights of teachers, and 3 times to protect new laws that limit the rights of transgender youth. These moves followed Saskatchewan, invoking the clause preemptively to insulate its own law policing names and pronouns in schools. And of course, that move followed the Quebec government using it preemptively in 2022 to protect an expansion of French language laws, and yes, the controversial Bill 21 passed in 2019. Here in Ontario, Premier Ford has used or threatened to use the clause 3 times. 1, a law that explicitly preferenced political parties by restricting third-party spending. 2, proposed legislation that would have banned education workers from striking, thankfully walked back in the face of public pushback. And 3, he threatened to use it when he messed around in Toronto's 2018 municipal election. These are all controversial uses of the notwithstanding clause, and they are mostly preemptive uses. Not where a parliamentary body, after careful consideration, believes that the courts have gotten a decision wrong on a matter of important public policy. No, this is where parliaments are afraid of judicial scrutiny entirely. And if we aren't careful here, charter rights will mean less than they should. And sure, there is no doubt that judges are fallible. Of course they are. Just look at Citizens United in the U.S. and the damage it has wrought on American democracy. It is also true, though, that populist decision-making through parliaments can lead to the tyranny of the majority versus minority rights, and history is littered with these rights violations. So the notwithstanding clause was a trade-off, and new rules are unfortunately but clearly needed to constrain the clause's misuse. Interestingly, Peter Lougheed, yes, the same Alberta Premier and champion of the clause, he offers us a useful way forward. Because 25 years ago, he argued for 3 straightforward amendments. First, if the notwithstanding clause is used, a legislature should be required to spell out with specificity very clearly the purpose of the law. 2, such an extraordinary measure should require a higher level of authorization than a simple majority. Lougheed argued here for a supermajority of 60%. I would go higher than that, but the general point stands. 3, there should be no preemptive use, none. No preemptive use of the clause. It should only be used after careful consideration of a judicial decision. Now, our Supreme Court can and should address this last point at least in part, because if anything good comes from the Bill 21 case, it'll be that judges can still weigh in with reasons that explain whether or not a right has been unreasonably infringed, even if the notwithstanding clause prevents a more meaningful judicial remedy. Of course, that paper judgment might help inform public debate, but it means very little to those who have had their rights infringed. Parliaments, both federal and provincial, we should act together to amend the Constitution and establish much stronger guardrails for the use of such an extraordinary measure. That is, we should act together to ensure charter rights are respected and protected.